Welcome to the webcast on preventing sexual harassment in the workplace. My name is Jill Clonferro, and I'm the Information Officer for the Alberta Human Rights Commission. Today's presenter is Sushila Sami, Diversity Specialist with the Alberta Human Rights Commission. The human rights legislation referred to in this webcast is the Alberta Human Rights Act. The Commission referenced is the Alberta Human Rights Commission. We would like to advise you that the information presented in today's webcast is not legal advice. It is information that your organization can use to prevent sexual harassment in your workplace. In today's presentation, we will gain an understanding of sexual harassment and the employer's responsibility in preventing it and the manager's role in dealing with it. There is a greater understanding of the adverse effects of sexual harassment and greater motivation to prevent it. The Commission is offering this webcast to emphasize the responsibility of employers and supervisors in preventing sexual harassment. Also to inform employers of their responsibility in creating and maintaining a safe workplace free of sexual harassment. And also to alert employers of the changes to the occupational health and safety legislation protecting workers from workplace violence and harassment. In this webcast, we are discussing sexual harassment in the workplace. It is important for employers to remember that clients and customers could also face harassment, and organizations have an obligation to ensure that they are not harassed. It is easier to take the steps to prevent sexual harassment than to deal with the repercussions after a complaint is made. Once allegations of sexual harassment are made public, there may be substantial damage to the organization and individuals. I will now turn it over to Sushila.
The Alberta Human Rights Act prohibits discrimination on 15 grounds. The Act also protects individuals from discrimination, including sexual harassment, in 6 areas: employment practices, employment applications and advertisements, and membership in trade unions, employers' organizations, or occupational associations. You can find information on the areas and grounds in the Commission's information sheet entitled Protected Areas and Grounds under the Alberta Human Rights Act, which is available on our website. A detailed explanation of the protected areas and grounds is provided in the webcast, the Alberta Human Rights Act Overview, on the Commission's e-learning page. A link to these is available on the resource list. The Act prohibits retaliation. An employer cannot take any negative action against an employee for making a complaint, trying to make a complaint, giving information about a complaint, or helping someone else make a complaint. For example, if an employee provides information as a witness in the investigation of a complaint about sexual harassment, the employer cannot take any negative action against that employee for assisting in the investigation. The Act also prohibits individuals from making complaints with malicious intent that are frivolous, that is, with no merit whatsoever, or vexatious, made with the sole purpose of harassing another person. Jill will now provide some statistics on sexual harassment.
According to a recent study conducted by Angus Reid Institute, more than half of the women surveyed, or 52%, and more than 1 in 5, or 22%, of the men who answered say they've been sexually harassed at work. Nearly 9 in 10, or 89% of women, have taken steps to avoid unwanted sexual advances at work. The Institute conducted an online survey January 25th through 30th, 2018, among a representative randomized sample of 2,004 Canadian adults who are members of the Angus Reid Forum. Sushila will now address what is sexual harassment.
Sexual harassment is a form of discrimination based on the ground of gender under the Alberta Human Rights Act. It is unwelcome, offensive sexual behavior that adversely affects or threatens to affect, indirectly or directly, a person's job security, working conditions, prospects for promotion, earnings, and getting a job. It includes unwelcome sexual advances and requests for sexual favors. It may be perpetrated by a supervisor, a co-worker, contractor, consultant, a landlord, or a service provider. A form of sexual harassment called quid pro quo is when someone in a position of authority attempts to exert it over another employee with negative consequences. For example, a supervisor using their authority to decide on a person's job security, working conditions, promotions, and earnings attempts to coerce someone that works for them to grant sexual favors. If the worker agrees to the supervisor's request, tangible benefits follow. If the worker refuses, job benefits could be denied. Sexual harassment often involves an abuse of power by one person over another. It demeans and humiliates the employee. It creates an unhealthy, unproductive work environment. It can be one serious incident or a series of incidents.
Sheila, what else can you tell us about sexual harassment?
Sexual harassment, Jill, may be due to a power imbalance. Women are especially vulnerable because of their traditional lack of power and influence in the workplace. Therefore, those who experience sexual harassment may feel that they have to put up with the harassment and may be afraid to speak out for fear of losing their jobs. Sexual harassment in the workplace can be costly for employers in terms of financial costs and employee morale, especially when employers do not have effective sexual harassment policies in place or if they do not treat complaints seriously. Sexual harassment can be verbal, non-verbal, or physical conduct of a sexual nature. Behavior that is acceptable to both parties, such as dating or flirting, would not be considered sexual harassment.
Sexual harassment can be expressed in a variety of ways, from subtle to obvious. Here are some examples. Sexual harassment can be verbal, which includes suggestive sexual jokes and remarks about a person's body, clothes, appearance, or sex life. Unwelcome invitation or request for dates, whether direct or indirect. For example, not taking no for an answer from an employee who does not want to go out for lunch or date another employee. Language that puts men or women down. Suggestive or insulting sounds, such as kissing or wolf whistles. And finally, outright demands for sexual favors. It can be nonverbal, including sexual looks such as leering with suggestive overtones, lewd gestures, display of pornography or other sexually offensive or derogatory images, photographs, cartoons, and videos, including those sent by email. Practical jokes that result in awkwardness or embarrassment. And it can also be physical, which includes unwanted physical contact such as touching, patting, pinching, physical or sexual assault. Physical or sexual assault is a criminal offense, and the perpetrator of the assault may also be subject to criminal charges. So Sheila, can you tell us who is affected by sexual harassment?
The majority of sexual harassment complaints, Jill, are made by women about men harassing them. However, any gender can experience sexual harassment. Sexual harassment can occur between individuals of different genders, for example, male to female, or between individuals of the same gender, for example, female to female.
Are there any consequences to the employer when there is sexual harassment in the workplace?
There are many consequences when sexual harassment occurs at the workplace. High employee turnover. Employees who face sexual harassment may quit the organization without informing anyone of the reason. Increase in staff absenteeism. Stress, depression, anxiety, and an inability to sleep are quite common when someone is facing sexual harassment. As a result, the employee may become sick and may not come into work. Less productive. Employees are likely to be less productive as they are dealing with the sexual harassment or providing support to those being harassed. Poisoned or hostile work environment. Sexual harassment creates a hostile or poisoned work environment, not only for the employee being sexually harassed, but also for others in the workplace. A poisoned work environment is not a respectful work environment and includes unwelcome, insulting, and degrading comments and offensive behavior. Human rights complaint. When the organization does not deal with sexual harassment and allows it to continue, employees may bring their complaints to the union or to the Alberta Human Rights Commission, or they may take other legal action. Other consequences of sexual harassment include cost of dealing with a complaint. When complaints are made at the Alberta Human Rights Commission, or when other legal options are taken, it could become costly for the organizations. For example, most organizations involve their legal counsel to help deal with a complaint made to a Human Rights Commission. Settlement costs. Further, if there's found to be sexual harassment, the organization may be responsible for settlement costs, such as damages for injury to dignity and self-respect and lost wages. In 2018, an Ontario Human Rights Tribunal awarded $75,000 in damages for injury to dignity, feelings, and self-respect to an employee who was subjected to sexual harassment from her employer. Negative publicity. Once a complaint goes to a human rights tribunal or to the court, the decision on the complaint becomes public knowledge and may be reported in the media and in law journals. This could result in a negative public image for the organization and may even lead to the closing of a business. Even if the complaint did not go to a human rights tribunal or court, the employee who was sexually harassed is likely to tell others they know, which would create a negative image for the business. When businesses do not deal with allegations of sexual harassment, the stigma of sexual harassment can result in serious financial consequences for the business. An example of this is a tavern in Edmonton that was forced to close its door following allegations of sexual harassment. These allegations were posted on social media and reported on by public media outlets. Social media, which may have not substantiated the allegations of sexual harassment it is circulating, can have a tremendous impact on individuals or businesses. Sexual harassment, when not dealt with, may lead to sexual assault or other forms of violence.
So Sheila, what are the employer's responsibilities in dealing with sexual harassment?
Employers are responsible for maintaining a safe, healthy workplace free from sexual harassment for all its employees. Service providers must do the same for their customers and clients. This includes having an effective harassment prevention policy in place and ensuring that employees are aware of the policy. Having an effective policy can decrease an employer's liability if a human rights complaint is made. An employer is usually liable for any sexual harassment that occurs in the workplace, and especially if management knew or should have known about the sexual harassment. This includes situations where the manager or employer observes sexual harassment, when an employee informs them, or when a complaint is made to them. Prompt and appropriate action on sexual harassment complaints can reduce an employer's liability still further. Human rights tribunals have frequently stated that an employer should be held responsible for the sexual harassment caused by supervisory personnel. Lack of awareness by management does not necessarily eliminate this liability. The Supreme Court of Canada has said that employers are legally responsible for the actions of their employees in the course of employment, whether it takes place within or after normal office hours or outside the usual workplace, as long as it is work-related. For example, When an employee is asked to attend a company-sponsored event, any sexual harassment they face at the event would be considered sexual harassment in the course of employment. In addition, the recent changes to the Occupational Health and Safety Act states that employers and supervisors must ensure workers are not subjected to nor participate in workplace harassment, including sexual harassment and violence.
So Sheila, what can employers do to prevent sexual harassment of their employees?
There are a number of actions, Jill, that employers can take. Employers can lay the foundation for a respectful workplace and prevent sexual harassment in the organization by developing and implementing an effective harassment prevention policy that includes sexual harassment and shows their commitment to a respectful workplace. The Commission has several resources to assist with developing a policy, and these are provided on the resource list found in this webcast. Ensuring that all employees have a copy of the policy or access to the policy. It could be provided online and or posted in the areas where employees congregate, example, the lunchroom. Training employees to better understand their rights and responsibilities related to sexual harassment. The Commission provides workshops to help employers, managers, and employees understand their rights and responsibilities related to harassment in the workplace. Training managers and supervisors on how to deal with a complaint under their policy. Ensuring that employees understand the harassment prevention policy by explaining the purpose of the policy, how to make a complaint under the policy, who they should complain to, how the complaint will be handled, what steps will be taken if the allegations of sexual harassment were substantiated, and any other relevant information. Encouraging employees to speak up or contact management or other designated staff when they witness harassment. Even if there's no witness to the sexual harassment, this does not mean that the sexual harassment did not take place. The manager must still take the complaint seriously and deal with it effectively. Role modeling the behavior that is expected of employees. Remember that actions speak louder than words. Employees will follow the lead of management. It is also a good idea to regularly review the complaint process you have put in place.
So Sheila, what should a manager do if they receive a sexual harassment complaint from one of their employees?
First and foremost, Jill, managers should take complaints of harassment seriously. They should not ignore the complaint. When a complaint is ignored, the behavior is condoned. Sexual harassment does not stop unless action is taken. Listen to the employee and find out the allegations of the complaint. Advise the employee of any other steps they would have to take under the policy, such as providing a written statement of the allegations of the complaint. Inform the alleged harasser of the allegations and ask for a response. Ensure the employee complaining of sexual harassment and the alleged harasser are separated and not working together while the complaint is being handled. Also, resolve the complaint through investigation or through the process identified in the policy. Inform the employee that their complaint is being dealt with. If there is found to be harassment, managers must take the appropriate disciplinary action so the harasser understands that the behavior will not be tolerated. When dealing with the complaint, they should ensure that they take into consideration the impact of the sexual harassment on the individual experiencing the harassment and not the intent of the alleged harasser. For example, an employee who makes inappropriate sexual jokes might say that they thought it was funny and did not mean to offend anyone. However, just because they did not mean to offend does not mean it is not offensive to those listening to the jokes or those experiencing the harassing behaviors. Use the reasonable person standard for determining sexual harassment. That is, a reasonable person ought to know that the behavior was unwelcome. As we saw earlier, the Alberta Human Rights Act prohibits retaliation. Ensure that no negative action is taken against the person complaining about the sexual harassment, any witnesses, or anyone else that assists with the complaint. Sometimes an employee may inform the manager about being sexually harassed, but would want them to keep it confidential. A manager is required to take action to inform employees on the seriousness of sexual harassment. When dealing with sexual harassment, it is important to understand that the lack of an explicit objection does not mean that the employee welcomed the behavior. Look for other signs of discomfort. For example, an employee avoiding certain areas of the workplace or never wanting to be seen alone with a particular individual. These express lack of consent even without it being said out aloud. If a manager is uncertain about how to proceed, they should call trained resource people such as a human resource manager or the company's legal counsel. The manager can also call the Alberta Human Rights Commission's confidential inquiry line to get information on how to respond to the complaint. The phone number is provided later in this presentation.
So Sheila, what is the standard for the workplace?
Employers can set a standard like the BAR standard for behavior in the workplace. The BAR standard stands for B, businesslike and professional in all dealings with co-workers or members of the public. A, acceptable in a work setting, behave in a manner that is acceptable to everyone in the workplace. R, respectful of others and act accordingly. I will now turn this to Jill, who will set the scenario.
I will present a scenario taken from a real case that will allow you to reflect on the actions you could take when faced with a complaint of sexual harassment. Rachel was a full-time housekeeper in a hotel and was pregnant when she was hired. One day, the newly hired manager asked Rachel if there was a clean room to have a quick discussion. Rachel suggested they meet in his office, but he wanted to meet in one of the guest rooms. At the end of their meeting, he made a sexual comment. She ignored it. A few weeks later, the manager made another crude sexual remark. Rachel was angry, but again, did not say anything. On yet another occasion, the manager spanked her on her bottom. Shortly after that, she received a letter of reprimand regarding her job performance and was told that if she could not handle her job because of her pregnancy, she could work elsewhere. A week later, she received a termination letter. She thought that complaints had to be made to the manager, so she did not inform anyone of the harassment. After her employment was terminated, she filed a complaint with the Human Rights Commission. At the hearing, the owner argued that he should not be held responsible for the manager's behavior. In your opinion, is the owner of the hotel responsible for the manager sexually harassing Rachel? The owner of the hotel is responsible for the actions of the manager. The owner of the hotel hired the manager to operate the day-to-day functions of the hotel and oversee the business and also to carry out managerial and supervisory functions in the workplace. Human rights tribunals have frequently stated that an employer should be held responsible for the sexual harassment caused by supervisory personnel. Lack of awareness does not necessarily eliminate this liability. What steps could the company have taken to prevent the sexual harassment? Answers to question 2 include: the company should have developed a sexual harassment or harassment prevention policy. They should have ensured that employees are aware of the policy and understood it. They also should have advised the manager of the policy and his responsibility in preventing harassment. Having an effective harassment policy can reduce an employer's liability when a human rights complaint is made. And finally, they should have provided information on who to report to if the employees were harassed by the manager. Further, the owner should have monitored the workplace more closely to ensure that there was no inappropriate behavior, especially since the manager was newly hired. And finally, they should have held discussion with the employees on how they were being treated at work. Take a moment to think how your organization would deal with a complaint of sexual harassment. Organizations should take the allegation of sexual harassment seriously and deal with it immediately. They should also follow the process outlined in their policy, take appropriate disciplinary action if there is found to be harassment, and ensure employees understand that harassment will not be tolerated in the organization. And finally, inform employees of the consequences if there was found to be harassment. The Alberta Human Rights Commission has a number of resources to assist you, including information sheets related to sexual harassment. They are sexual harassment, developing and implementing an effective harassment and sexual harassment policy, and protected areas and grounds under the Alberta Human Rights Act. These information sheets are on the resource list on the audience console. Another resource available to you is a video scenario on sexual harassment that you can access on our YouTube channel called Indira's Story, which portrays Indira's experiences with sexual harassment at her workplace. You can find it and other video scenarios in the e-learning section of our website. We also have webcasts on the Commission's e-learning page that provide information on the Act and on harassment in the areas and grounds of the Act. These include an overview of Alberta's human rights legislation, the Alberta Human Rights Act, developing and implementing an effective harassment prevention policy, roles and responsibilities of employers in preventing harassment in the workplace, and I am being harassed or witnessing harassment. What should I do? You can also sign up for our free online newsletter, the Alberta Human Rights Information Service, offering information on recent tribunal and court decisions, Commission policies, and other news related to human rights and diversity. If you have a specific situation or want to learn more about making a human rights complaint, you can call the Commission's confidential inquiry line to speak to a human rights officer. The information is listed here, or you can visit the Contact Us page on our website. As mentioned, you can contact us by email at educationcommunityservices@gov.ab.ca.